All right, welcome back to the Special Committee on Impeachment Inquiry. And this afternoon, we are going to hear from folks who worked on the Paul Franklin Collins investigative report. We will start with a kind of a general overview for public consumption, and then we are going to have to move into executive session to take up and look more closely at the confidential components of the report. Before we do that, if we could get a quick update from Representative Nolan and Byron as far as our efforts in seeking an investigator to help us with the matter of the sheriff on Wismore.
Yeah, so we've been working closely with Michael Grady from Legislative Council, and kind of similar to what we saw as the contract for, what was that for? For the special counsel piece, we've been working to develop that content and do the scope of work for it. So we have that defined and been reaching out to entities around that. And we did not do the sole source contract piece of it, did the simplified bidding, which means that we have to reach out to at least 3 entities. And so we're in the process of reaching out to folks. We actually have a couple more. We did one interview yesterday with somebody that is interested in submitting a bid, and we have potentially 2 more after today's committee meeting. And so our hope is to come up with a recommendation soon and bring it to the group.
Great.
Yeah, so hoping to have more details on the prospects by early next week.
Good. Perfect. So hopefully,
Was it like you have to reach out to 3 people, or do you have to have 3 bids?
You have to make contact with. Yeah, but what we did was we had our initial punch list. Some folks didn't have capacity. You know, some people just didn't have the bench within their organization, whatnot. So we actually extended. We looked beyond the scope of the original 7 that was put together. And that is where we're at today. We're speaking to 2 of them once the committee breaks. So we've probably, once it's said and done, we'll have reached out to and or spoken to probably 6, 7.
And did I understand correctly that you're focused on firms that have in-house regulatory capacity?
Yes, that's something that we've been wanting to have be some to not have them outsourcing the investigatory charge to help mitigate any potential what's the word I'm looking for? Yeah, attorney-client privilege. Yes, thank you. To have it be known in-house. Yeah.
all right. So hopefully we're going to be back here next week, starting with witness testimony, and perhaps we'll have something to move along on that as well. All right, well, with that, we're going to move to Chris Brines and Karen Stackpole. If you could join us. This morning, we already heard from Annie Noonan, who is still online, but she went over the process that led to you folks being hired to do this investigative report. And if we could hear from you kind of the general process, and then we'll move into executive session to get into the confidential components of the report.
Sure. Well, thank you, Mr. Chair. I appreciate the opportunity to be here. I'm Karen Stackpole. This is Chris Brines. Sometimes we do that opposite just to kind of mix it up. So we are both partners at Paul Franklin Collins. We are both leaders in the labor employment group. I guess officially it's the employment and labor group. And so it is part of our practice not only to do litigation and represent clients in litigation, but also we perform independent investigations and have for a number of years. We have done them for various public entities like public colleges and universities. We have done them for private companies, some that have been publicly traded and some that have been private. So we've done them in a lot of different contexts, lots of municipalities too, that we've done investigations in. And so I have been in practice now for about 30 some odd years. I can't speak for you, Chris.
15 years.
There you go. So we've done 2 or 3 of these, being facetious a little bit. What we try and do is really think about fact finding. Generally speaking, we like to separate out for our clients fact finding versus conclusion making. So much as you're working on that in this case. And the idea being that if you can be independent and just hear what people have to say, you can make conclusions of fact. So at the end of the day, you can say, yes, so-and-so said this, or no, so-and-so, there's no evidence that this person said that kind of thing. Obviously, there's going to be contested facts, and there often are contested facts. And when that happens, we do have to sometimes make a judgment call based on the credibility of the people with whom we spoke, any additional evidence that might support the conclusion that we make that isn't evidentiary from speaking, from people providing testimony, but rather documents and things like that. So our first process is to take a look at what's the scope of the work, what's the question that really needs to be answered. And then we ask the client for who are the potential witnesses that you're aware of. So we make a list of potential witnesses are. And we then ask for relevant documents that may tell us a little bit about the allegations that have been made. And at that point, Chris and I usually, to be cost effective and timely, we usually split up who will talk to whom. And it's situational. It's not a specific, formula. And then we individually will do most of our different interviews. And sometimes we do some interviews together. And we do them together because there may be times when we perceive somebody as a critical witness who we want more than one person to take a look at and kind of help us with that credibility judgment. And we did that. We followed that essentially that pattern here. And then what we do is, depending on what the client requests, we either do a long and very detailed with attachments kind of report, or we do a summary type of report. Here we did a summary type of report where we didn't attach documents necessarily, but basically gave an overview of the conclusions that we reached based on the allegations that had been made. That's my basic summary. Something to add?
Yeah, I would just add that our job going into these investigations, they do typically relate to discriminatory conduct. So we are typically engaged when there is a legal framework that the client is focused on. And in terms of how we divvy up witnesses and then join together, I would say that in this particular case, especially because we had separate lists of witnesses before talking to an accused generally in an investigation, we're able to then go into that final interview with our own subset of information that we've gathered from witnesses individually, so that we can see it from different angles and then work together also to kind of assess credibility and supporting documents or information before we reach conclusions. I think we also have a very standard process when we begin interviews, and that's something that Karen and I make sure that we individually do. Where as a very first piece of information that we share with witnesses, we talk about confidentiality and what the scope of that looks like. We talk about retaliation to let folks know that they cannot be subject to retaliation and they cannot retaliate against anybody else. And we explain our role as factors because we're not acting as counsel to a particular entity in these sorts of investigations. We are fact investigators.
And if people have questions, if some of the witnesses have questions about that process, we always send them back to the source, to the entity that hired us to answer any, specific questions about how something will be handled. And I will say that with regard to confidentiality, for most witnesses in most situations, we really can't require confidentiality because there are rules, there are laws that would allow people to have some communication with other individuals. But for those individuals who are, for example, managerial employees, we will say you need to be confidential about this. And we explain confidentiality to other witnesses as kind of a tool for us. We can't demand it of them, but to say it's helpful for us if you don't talk about the substance of what we asked you about or what you told us to other people. That's because we'll start hearing the same thing over and over and over. So after a while, it's like a game of telephone. And so what we ask them is, certainly feel free to tell somebody that you spoke with us. Yes, I spent an hour talking to, so-and-so this morning, or I spent 2 hours talking to so-and-so. That's fine, but please don't talk about the substance, because what we would like to do is get a fresh perspective from each person who comes to talk to us. So that's kind of how we handle the confidentiality piece. And it is really important for us to talk to each witness about retaliation, because that sometimes happens in these situations, is that people are aware that somebody may have literally just spoken to the investigator, and they may be subject to retaliation, or somebody retaliates against somebody. And so either, we want to try and avoid that by letting people know that that in and of itself is not an okay thing, and that if people feel as though they are being retaliated against, they should go back to our source, person and report that accordingly.
So any questions at this stage? I just had one question. Do you record the interviews that you do?
So I do not, and Chris does not. We did not in this instance. I still take notes with a pen and paper, which to the consternation of many people in my office, including Chris. Chris has a tendency to take things more electronically, but I feel as though it gives somebody, just my view is that if you record it, I feel like sometimes people get really tight. They get really worried about what's being said, and it's less conversational, and you can learn less from that person, and then they open up less. So that's been my practice for most of my career.
Agreed. I think it really changes the dynamic with the witness and establishing rapport. We have different styles. I tend to take notes more or less verbatim or shorthand for verbatim, so that I really have a solid memory of exactly what the person said. And that works well together, because we can kind of focus on different aspects of interviews together.
And when we finally do our report, the two of us come together, and either one of us takes the lead in terms of writing, what they see from the notes or see from what they participated in. And then the other comes in and does, edits and helps out. And we make a final agreement as to what we think is the report that we will let go. And then we publish it to the client.
You have one question?
Yeah, go ahead.
I appreciate this and understanding that it's the fact-finding piece and the investigatory piece, not coming up with the conclusions of it. So my question is, how do you know when you've gathered enough information? Like, how do you just make that point of, okay, I think there's enough here?
So that's a great question. So we do talk throughout, obviously. It's like, so who are the people that you talked to today, and what was the basic tone? I mean, I think, to be frank, in an investigation, a question that I always ask everybody is there somebody else you think we should talk to? So whenever we're talking to witnesses, who else do you think I should talk to? I may not choose to talk to each of those people, but at least I have a sense from you of who some other people might be who would have information. Do you have any documents that would be helpful for me in my evaluation? So we will sometimes get those. So when things start repeating themselves is generally when we figure we probably have enough here to make, to call it and to do our conclusions from here. And so I think it has been rare that has resulted in, a conclusion that's really far off, because you're hearing the same thing over and over again, or you've had enough confirmation. Somebody sends you a document, like, oh, that is what you said it was. And so done, kind of thing. And so that's generally how we know we're towards the end.
I would say it depends on how disputed a particular fact is. If particularly the person who's alleged to have engaged in problematic behavior admits something, there's not a need to keep going and going. And in this instance, we did talk to every employee in the office. So it was a broad scope in terms of where we.
Other questions?
Oh, the only other thing that I will add is that people in this particular investigation, people were provided the opportunity to the extent that it was applicable to them to have a union representative present. And several people took that opportunity and their union representative was present, but many people did not.
Appreciate that. So I know that the report, the investigative report, was released in a redacted manner from the Department of State's attorneys that redacted the names of witnesses and some other information, I believe. And I think really our next step to really move along in our investigation of State's Attorney John Lavoie, that we're going to need to look at that confidential information. So therefore, I'm going to ask for a motion to go into executive session 10 minutes after our vote, on this motion, to review the unredacted version of the Paul Franklin Collins investigative report and to discuss next steps based on that review. Do I have that motion?
So moved.
I have a so moved and I have a second. I appreciate it. And I can open this for discussion, but I will start by explaining really the rationale for us to be able to go into executive session in this instance is, again, we're going to be preventing the disclosure of information that is confidential under law, the unredacted components of this investigative report. Furthermore, we're going to be proceeding in executive session to protect the witnesses' identification in the investigative report and protect them from potential retaliation. So with that motion, is there any other discussion regarding the motion? If not, all those in favor of going into executive session in 10 minutes, raise your hand. All right, we're going to, in 10 minutes, and we're set up in a different room, which we will go to and start in 10 minutes. It's the House Transportation has been kind enough to lend us their room for executive session. Fourth floor.
Top of the stairs.
Top of the stairs.